Good evening, my name is Eric Rinehart. I'm the Lake County State's Attorney. Yesterday, our office filed 7 counts of felony reckless conduct charges against Robert Crimo Jr., the father of the alleged shooter in the Highland Park parade case. Everyone deserves to feel safe in every community. For too long, we have allowed gun violence to destroy lives and neighborhoods. We have allowed a cloud of fear to hang over every part of American life. No brother should fear dropping their younger sibling off at school. No aunt should fear taking her niece to a neighborhood barbecue. And no daughter should fear standing with her mother at a July 4th parade. As we all work together to address the root causes of crime, to hold shooters accountable for their actions in the courts, and to pass common sense gun safety legislation, we must also remember the long-standing principle that people bear responsibility for when they recklessly endanger others. These are the moral and legal foundations upon which these charges rest. Robert Crimo Jr., again, the father, took a reckless and unjustified risk when he decided on December 16, 2019, to sign his son's application for a firearm owner's ID, or FOID, card. At the time he signed the application, his son was 19 and could not, let me say that again, could not get a FOID card, and because of that could not legally purchase a firearm without his father's assistance in that application process. Our system only allows 18, 19, and 20-year-olds to acquire FOID cards and weapons if they have the authorization and participation of their parent or guardian. Parents and guardians are in the best position to decide whether their teenagers should have a weapon. They are the first line of defense. In this case, the system failed when Robert Crimo Jr. sponsored his son. He knew what he knew, and he signed the form anyway. This was criminally reckless and a contributing cause to the bodily harm suffered by the victims on July 4th. Mr. Crimo Jr. will appear tomorrow before in court to have a bond set. He turned himself in this afternoon to the Highland Park Police Department. This prosecution is 7 counts. It is brought in the names of the 7 people who died on July 4th. Jacqueline, Nicholas, Catherine, Irina, Kevin, Stephen, and Eduardo deserve decisive action from this office as well as from legislators. For too long, we have allowed a vocal minority to drown out the will of the majority and to stall common sense legislation about gun safety. Shattered communities deserve better. Gun violence is a uniquely American devastation, but it is not destiny. It is a decision. And in my role of State's Attorney of Lake County and as a father, I am once again asking legislators to make the decision that this will never happen again by banning assault weapons and large capacity magazines. I'm happy to answer a few questions, but I want to remind everybody this is a pending case. I will not be getting into the specifics of the evidence.
So Illinois State Police approved the application the dad sponsored. So what is the reckless conduct?
Yep, that's a good question. It's because of the information that the father had about his own son. If you look at the reckless conduct statute, it describes it's any conduct by any means lawful or unlawful. So the conduct itself doesn't have to be by itself unlawful, right? It's not a DUI, and a DUI is unlawful, and that's also reckless conduct. It can be, of course, lawful actions. So based on what the father knew, the specific information that the father knew, he was reckless, and it was reckless conduct.
What was that specific info?
Not going to answer that. I'm not going to get into the specifics of the evidence.
What does he have to attest to the son's fitness conduct?
Great question.
What does he have to?
Great question. He doesn't. He doesn't. The FOID application, which I believe is changing, I would refer you to questions to the Illinois State Police about the specifics of the application. But the FOID application is something that he simply has to sign. He answers a few questions about himself. I was very surprised by that. He's answering questions about himself not about the person receiving the FOID card. But the parents know what is going on with their teenagers. And so he knows what's going on, and it was reckless for him to participate in the FOID process in that way in this case.
Mr. Rinehart, is it possible that you could talk to the state's attorney, as the state's attorney, talk to the state rep and the state senator to probably getting that law, getting that off the application?
Yes, great question. My understanding is that there are some changes that have already happened internally in the Illinois State Police. My understanding is that there's also legislation, proposed legislation, of course, that will change some parts of the FOID application process, as well as potentially the ages of when you can receive a FOID card.
If he's convicted on all 7 charges, what's the most punishment he can face?
Each count of reckless conduct is a felony. Each count of reckless conduct faces up to 3 years in prison. Typically, reckless conduct charges are concurrently, so it would be 3 years in prison.
What would be your recommendation in terms of you've seen as a flight risk?
Yeah, great question. I really don't want to get into that because there will be a bond hearing tomorrow, and we're going to have to actually argue that tomorrow. And I don't want to highlight our argument in that way. We need to make that argument tomorrow, and we'll let you know what we talk about tomorrow. But I think that's a fair question. He did surrender himself, which is an important part of the process, and he will be in court before a judge tomorrow morning.
When we've asked the family or the family's attorneys about his involvement in the FOID process, they've always thrown it back at ISP. They've said ISP should have seen or known that he could have been dangerous. Any response to that?
ISP does not know more than someone about their son. The government is not typically going to know more than a parent about what is going on with the minor, not the minor, but the 18, 19, or 20-year-old.
A class 4 felony, it's probationable?
Yes. Class 4 felony is probation up to and including 3 years in prison. Okay, I appreciate it. Thank you very much for all being here. Any other questions? Okay, thank you very much.